Hello everyone! In this video we are going to explain the basics of working conditions. First of all, we are going to define the employment relationship, which is the legal link between employers and employees. It exists when a person performs work or services under certain conditions in return for remuneration. As in every type of contract, conditions are set. These working conditions refers to the working environment and aspects of an employee's terms and conditions of employment. And in this case, it is directly linked to the rights and duties of the employee with the company. Working conditions are set based on three levels. First, state-set standards are the one in which it is established the minimum standards and conditions that every employee should have by contract. No contract or agreement can provide worse conditions than the standards. Second, collective bargaining are the ones which can be negotiated for a certain segment of workers or for the employees of a specific company. These conditions should always be above the minimum standards and provide the worker with the better situation. And third, individual negotiation. This level is the one in which more adjusted conditions are set for the employee himself. Note that these conditions must always be above the minimum and the collective bargaining.
Now, having explained this basic information, we are going to explain the most relevant working conditions. These rights are: first, minimum age. The minimum age for work legally is 15, which is the age of completion of compulsory schooling. There are some exceptional cases in less developed countries, where the minimum age would be 14 years old. However, in case of light work, the minimum age would be 13. Those jobs, such as modeling, working on theatre or television, must not prejudice their school attendance in order to be legal. Second, wage. Wages can be regulated by the state or by every different working sector. The European Union is not responsible of the wage setting of every country. A minimum wage should be stated by every country government, as it takes into account the type of labor relation of each country. It can be established two types of minimum wages: a statutory minimum wage decided by the state and sectoral wages decided by collective bargaining, which must be always above the minimum statutory wage. Third, occupational health and safety. In addition to the wage, another condition to bear in mind is the health and safety of the workers. That is a matter not only of contractual agreement, but also a moral matter. For that reason, it follows specific directives by the European Union. The European Union legislation has established some minimum standards regarding some activities that could be harmful for the workers, such as working with chemical agents, exposure to ionizing radiation, and exposure to loud noises or vibrations.
Fourth, working hours. Last but not least, we have working hours. Limiting working time should be treated as a health issue as well, as it can affect the employee physically and psychologically. The main aspects treated here are: first, maximum working time. The average working time should not exceed 48 hours for its 7-day period. The reference period should not exceed 4 months. Second, rest periods. Here we have breaks. When the working day is longer than 6 hours, every worker is entitled to have a rest break. Concerning breaks, we have daily rest, weekly rest period, and annual leave. Last, night shifts work and obviously life-work balance. It entitles employees to have reduction of hours or reorganization of their schedules, usually granted to parents and family carers.
Thank you for watching today's video. We hope you like it. Don't forget to give thumbs up and subscribe to our YouTube channel.
See you in the next one!